Hello and welcome to the BRR Legal Brief, bringing you the latest legal issues affecting corporate Australia. I'm Kate Ritchie. Well, a little over a week ago, we saw the landmark ruling in the Lehman class action, with a federal court finding that Lehman was liable for the losses suffered by a number of Australian charities and councils. Joining me to discuss the decision and what it means for class actions in Australia is Alex Morris, who's a partner at King Wood Mallesons. Alex, thank you for joining me in the studio.
Thank you, Kate.
Well, Alex, before we get into the nitty-gritty of the implications, can you give us some background details to this case?
Yeah, well, I'll do my best. It's a 400-page decision.
Yeah.
Look, this involved a claim by 72 councils and charities against Grange Securities. Grange became effectively the local subsidiary of the US investment bank Lehman Brothers that obviously went into external administration during the GFC. These councils invested in some products known as synthetic collateralised debt obligations, I won't say that twice, which were sold to it by Grange. So Grange basically gave them investment advice and sold these products over the counter to them. And in respect of some of the councils, Grange actually then took on a role of being an investment manager. So it was making buying and selling decisions on their behalf to buy these things. These products were rated either AAA or AAA minus, but notwithstanding that, they were highly complex and provided an economic exposure to things including the US mortgage market. And in the event of ratings downgrades on certain classes of mortgage securities in the US or other sorts of credit events, that could fundamentally affect the capital value of these products. If you've read Michael Lewis's The Big Short, he gives a fairly entertaining, if opinionated, view on these sorts of products. Anyway, history records the GFC occurred and there were substantial credit events, with the result that the value of these products declined substantially and some of them declined to nothing. So these councils got together with Australia's leading litigation funder, IMF, and IMF effectively funded a class action in the federal court against Grange Securities, with a few councils effectively being the representative applicants on behalf of the larger class. In those proceedings, the councils brought allegations against Grange that effectively in either providing investment advice on these SCDOs or in providing portfolio management services in respect of the SCDOs, Grange engaged in misleading and deceptive conduct, breach of contract, negligence and breach of fiduciary duty. In his judgment handed down Friday before last, His Honour Justice Raries of the Federal Court effectively found for the councils very comprehensively. So he effectively found that Grange had engaged in misleading and deceptive conduct, had breached contractual obligations, had been negligent and had breached its fiduciary duties.
Well, Alex, you've mentioned that the decision was 400 pages long. What do you see as the key considerations for the court?
Look, the main takeout or the main approach of the court here was a really quite detailed analysis about the nature of these products. And as I said, let's not delve into the detail, but the court effectively went through and said, look, here's this product, objectively it has these benefits and these risks. Here's what Grange said to its clients about them. Here's what Grange disclosed about its interests in these products to its clients. And here's the investment advice Grange provided. So it was effectively that balancing act. And clearly Justice Raries, on doing that balancing act, came to the conclusion that the weights were not on Grange's side and that Grange hadn't provided adequate advice or portfolio management services.
Well, Alex, do you see this as a surprising decision in any way?
Look, I don't think the legal principles that His Honour applied, as in the abstract sense, were in any sense surprising. These are well recognised causes of action in this jurisdiction. They often come as a surprise to people from outside of Australia,
Yeah.
but I think legally a lot of it's fairly expectable. What is interesting is the application to the facts of this case. And I think that may surprise some people at the more sophisticated end of our financial services industry.
Mm-hmm.
One particular takeout is that His Honour really didn't have much truck with the position put by Grange that the councils ought to be primarily responsible for their own investment decision making. In a sense, His Honour took the view, no, Grange had taken on that responsibility for the councils, and you can't blame the councils. The other area he didn't place much store in was Grange in its documentation had a number of standard disclaimers. So disclaimers saying, you know, our subsidiaries may have interests in these products and the like. His Honour took a fairly critical approach to the suggestion that Grange could successfully attenuate its duties there, and I think that might come as a surprise to some.
Okay. Well, I'd like to focus on class actions generally in Australia. Do you see this class action as differing from some of the other class actions that we've seen earlier?
Yes, I think it does. I think this is an interesting new direction in class actions. At the moment in Australia, there is a really well-developed securities class action market in the traditional securities class action. And, you know, I did the multiplex, I did the Centro class actions, and those are, from the plaintiff side, almost cookie cutter these days. You have a listed company, it has a disclosure problem of some variety, so allegedly breaches continuous disclosure, allegedly engages in misleading and deceptive conduct. And you'll get plaintiffs who allege, well, because of those breaches, the market price was inflated. And then the argument will be put, everyone who bought securities at those inflated prices suffered a loss. And that's a kind of claim which is designed to really remove the role of individual decision making. It's an attempt to really run a case which is, I suffer my loss when I buy something on market at overvalue. It doesn't matter if I actually knew what the company did or didn't disclose. It was simply the act of buying it that lost me money. And those actions are run by, you know, two firms in particular in Australia who specialise in what you'd call plaintiff class actions, be they securities class actions or be they product liability or industrial matters. By contrast, this claim, although funded by the kind of standard litigation funder, was run by a commercial law firm, Piper Alderman, and the nature of the claim and how it was done was a bit different because this was, in some ways, very much about individual investment decisions by individual counsels, but the plaintiffs managed to do it in a class action framework. And to prove their case here, the plaintiffs did actually have to have their own investment decision making looked into. So the representative counsels actually had to put their investment decision makers in the box and have them cross-examined. That's something we haven't seen happen in securities class actions to date in Australia, so that's quite a development. So I think that is a difference, and it shows that effectively the class action regime can be used for what you'd call a more traditional style of commercial litigation. I think we're seeing this move outside of the kind of access to justice sort of area, which the plaintiff firms try to present it as, into effectively the world of complex commercial litigation where some sophisticated investors who've lost money may get together, get a commercial law firm to run the case for them, and use the class action system to their benefit.
It's an interesting development. I'd like to focus on reform, looking at, say, the investor protection regime and whether you think we're likely to see reform following this decision.
Well, always an interesting question. Realistically, I think that we're now in the last year of this electoral cycle at a federal level. We've just had the future of financial advice reforms. They're really starting to kind of be bedded in, but a lot of financial intermediaries are still dealing with the outworkings of that. And I think there may be a kind of a degree of regulation tiredness, because we've seen a lot happen after the GFC. So I would be surprised if we see something in the next little while. As to whether this case indicates the need for more investor protection at the kind of top end of the market, I think that is an interesting question. I think in terms of retail protection, we are a very regulated country in Australia. People from overseas are always surprised. At the sophisticated end of the market, my personal view is we are incredibly regulated as well. So there are statutory protections, particularly misleading and deceptive conduct in Australia, that often astound people coming from other jurisdictions. And it would be a very, very brave participant in the Australian financial services industry who thought you could effectively deal with sophisticated investors on a buyer beware sort of basis. So personally, no, I don't think we need reform. The other area is we have the laws we have. Obviously, Justice Rares thinks there were issues with compliance there. Is there an issue here that the regulator ASIC hadn't been doing enough at the sophisticated end of the market? And I think there one would fairly acknowledge that ASIC obviously does a lot less at that end of the market as compared to the retail end of the market. But all in all, and it's again a personal view, ASIC has a limited budget to do what it has to do, and obviously wants to get the biggest bang for its buck. It could be said actually this case demonstrates very neatly that effectively our legal regime, and particularly our class actions regime, and the availability of litigation funding in this jurisdiction actually makes for a dual-track regulatory system. Effectively, there are private remedies available, particularly to people with potentially big claims, and I think the system's working quite well at the moment.
Okay. Well, just finally, obviously we've had the decision in this case, but it's not over. I'd like to find out what are the next steps in Oz and whether you think the decision here will have impacts on similar actions globally.
The position here in Oz, I think we're going to have actually a very interesting little period. There is currently reserved another judgment relating to these sorts of products, and those were proceedings brought against one of the ratings agencies in respect of one of these products. That's reserved, so it'll be interesting to see how that comes out. Interesting that a different target was picked, and interestingly that proceeding was also bought by Piper Alderman, who are obviously trying to build a little section in the market here as the kind of commercial lawyer's version of the plaintiff firm. Out of this immediate class action, there's also a kind of sidelight, which is that 72 councils were in this class action. There were a number of other local councils who invested, apparently, with Lehman, who didn't join this class action. And certainly IMF was out in the press. I think they were in the 7:30 report a few months back, making some comments about that, and maybe these councils should join. What those councils now do will be very interesting. One would think they would be seriously looking at mounting their own claims. Obviously, they won't have to pay a cut of their winnings to a litigation funder if they decide to fund this for themselves. So they may have actually got a free ride off the back of these councils and the funding IMF provided. So we'll have to see what happens there. Globally, there are obviously a number of these actions running globally. Other jurisdictions do not have our misleading and deceptive conduct regime. I think that gives a real boost. That said, and obviously we have to see how the appeals play out on this case, but obviously they will have in those jurisdictions claims under their local securities legislation potentially, but obviously the same sort of fiduciary negligence and breach of contracts claims. So plaintiffs in those jurisdictions might take some heart from this. One interesting comparison, of course, will be to see how successful the class action regimes in those jurisdictions allow people to group these things conveniently together. Obviously, that has worked very well for the plaintiffs here. It'll be interesting just to compare how that works out in other jurisdictions.
Well, it's definitely an interesting space, and it will be great to see how the market develops in this area. Alex, thank you so much for your insights today.
Thank you very much, Kate.
And viewers, thank you for joining us also. We hope that you can join us next week for our legal brief.